Hi everyone, my name's Jacqui Brown, and as Heidi said, I'm the Safeguarding and Transition Lead at Rainbows Hospice. I haven't always been in safeguarding, so I'm a neuro OT by background, with a history of working in with traumatic brain injury and severe and enduring mental health problems in adults. Are we doing Chris Whitty? Can you move the slide on?
Yeah, sure can.
Okay. So this is not going to be a repeat of all the different Mental Capacity Act training that you've been on. This is about the Mental Capacity Act in practice and Rainbow's journey to becoming 100% compliant, which is a big thing to say. And I'm here today feeling very proud, but knowing that it's been a massive team effort. So it's been everyone involved really in getting us to the stage where we feel really confident with our processes.
Sorry, I've moved that on.
No, that's fine. I'm ready.
Ready?
Yep. So just a wee bit about Rainbows. So Rainbows is the East Midlands only hospice for babies, children and young people up to the age of 25. And that's really important, I think, to stress, because people often think of Rainbows being a children's hospice. We are a children's hospice, but we're also a hospice for young adults as well. Our referral criteria is that the baby, child or young person has to have a life-limiting, life-threatening condition. And we don't just offer things that go on within the hospice itself. So we've got a really big and very experienced family support team comprising of nurses, support workers, and then the specialist roles. We've got Sharon in the audience with us today, who's our transition coordinator, but we've also got youth work, sibling support, music therapy, Sharon's probably screaming at me now, cultural support workers, so a big wider team. But essentially we are there to provide support for families, short stays and when the time comes, end of life care. Thank you. So when we were looking at mental capacity, we were looking at a cultural shift, and compliance is the result that we've got, but it was never the aim. So whilst it's lovely to say that we're 100% compliant with the Mental Capacity Act and DOLS, the aim was always to instill the belief in staff, no matter what their role, that they are responsible for protecting and championing the rights of those we care for. It was also really important as well to validate the good practice that was going on. So we weren't compliant. 4 years ago, we were not compliant, but that did not mean to say that capacity wasn't being assessed, because it was. It was being assessed all the time in all the different practice of every member of staff. But what we weren't doing was recording it. To get a shift in the belief of staff members, we had to be mindful of the barriers. Time being a big one, and I'm sure everyone here will feel that pressure of time. 4 years ago, our capacity assessment was 8 pages long, and staff were saying they just did not have the time to be assessing on a decision-specific basis capacity when we were having to complete these 8 pages. So a lot of work went into actually looking at what is important, what is within the Act that we need to be able to provide evidence for. So we did manage to get the assessment down so that it is achievable for staff. Fear of change was always another one as well, feeling that it was yet another thing that they were being asked to do. So I think, again, going back to the fact this is not another thing you've been asked to do, you're doing this anyway. And a lack of confidence as well. So staff felt underconfident, or that it was someone else's role. However, I think it's really empowering when you sit and you talk with a healthcare assistant, for instance, and you're talking about personal care, and that is something that they are providing, and therefore, you know, they have every right and responsibility to be assessing capacity around that, and motivating staff so that they actually feel that they're part of something bigger. And then practicing with them and supporting them to do things that they thought they couldn't achieve. So it becomes habitual. And what I mean by that is now I'm not having to chase things because it's what we do. This is what we do. And the reason for that is actually partly on a video that we're going to play next, hopefully.
Okay, I shall give it a go. Can you hear it?
Yep.
I'll make it full screen.
We are all equal before the law.
Women and girls with disabilities should have the full rights and freedoms enjoyed by everyone in the community.
As children with disabilities, we have the right to express our views on matters that affect us.
We are capable and contributing members of society.
We have the right to physical access and information access.
We have that right to life.
We have the right to be rescued in times of disaster.
We have the right to equal recognition before the law.
We have the right to justice.
We have the right to live freely in the community, to live independently and be included.
We must not be tortured, exploited, or abused.
We have the same rights as others to choose where we live and where we travel.
We have the right to access information and to express opinions.
We have the right to privacy and to have intimate relationships.
Our children cannot be taken away just because of our disability.
We have the right to education, jobs, and healthcare.
We have the right to participate in cultural and public life.
Okay.
Thanks, Heidi. Yeah, I mean, just before we move on to our process, I think that video is so powerful, and Sharon and I do an awful lot of training around MCA, but we always show that because I think it, you know, sets the scene for what we're hoping to achieve. So moving on to Rainbow's process, we've got admissions nurses who will go out and do home visits before an admission. It was really important getting them on board so that they were able to do some preliminary work before the young person even sets foot in the building. So they will bring back information, really important information, before they come in. And first and foremost is the young person, an adult. Now, we know that the Mental Capacity Act talks about from the age of 16 up, and this is one where, and maybe some of you will think, well, we're not 100% compliant, but we concentrate from 18 up when it comes to gaining consent. We would do from the age of 16 if what the 16-year-old was saying was different to what the parent was saying. But because parents have PR, parental responsibility, up to the age of 18, we are able to take consent from them up to 18. But from 18, we no longer take consent from parents. So their admissions nurse will look at what the care needs are, likes and dislikes, really building that picture of the young person. They will do a preliminary assessment of whether or not they're able to provide informed consent for their stay and or their treatment. How do they best communicate? How do we need to be able to communicate with them when they come in? And what are the views of those who know them best? She will also explain about the Mental Capacity Act to parents. This is really crucial, especially when you've got a young person who's been with us for a number of years. They may have been coming for a number of years, but they may recently have turned 18. So Sharon in transition will work with parents to inform them about the changes in the law, but this will be reiterated by the admissions nurse, because parents will no longer have forms to be filling in. Thank you, Heidi. Following that pre-admission meeting, the admission nurse will come back, and this is a laminated A4 sheet, so you've got both sides there. And these are areas of where we provide interventions at the hospice. So if you do something similar yourself, yours will look different because it will replicate the interventions that you offer. And you notice that we've got some blank boxes there because we can add in. So if there is, you know, an intervention that we're providing and it's not on this list, then it's not an exhaustive list. I won't go all the way through it, but if you can see that, it's where we would ordinarily be asking the young person whether or not they would consent to something like having their catheter care done. Where we can't, then we're getting an indication of this is where we need to assess capacity and do things in best interest. Do you want to go on, Heidi? Yeah. So upon admission, all children and young people are allocated a nurse and a healthcare assistant. And they're all encouraged to be involved in their own admissions. So the admission process is fairly lengthy, because when we are being left to look after a child or a young person and their parents are not going to be there, then we need to know we're going to get it right. All the care plans are then developed in conjunction with the child, the young person and a family member. And we'll use communication aids or different methods of communication as appropriate. And again, this is overlooked sometimes when we're looking at assessing capacity, that someone, if they're unable to, you know, verbally communicate, then there can be assumptions made that they lack capacity. So we'll spend time getting to know them. We are very lucky that a lot of our young people we've known for a number of years. So we are aware of the best way of trying to communicate. So throughout that admission process and in the development of the care plans, the Act is applied throughout. And this was a really important thing to get across to staff, is that they may have not been documenting their capacity assessments, but they have been assessing capacity all the way along. So we presume that someone has capacity until proven otherwise. We are aware whether or not there is a disturbance or impairment of mind or brain. We do look at, can the decision wait? We do look at it being decision specific, but essentially those principles of, can they understand, retain the information, weigh up and communicate, is just part of the skill of the staff working with the children and young people. So the form is not the assessment, it's the documentation. And that 8-page assessment is no longer. And we used to have a paper document, which was 2 sides of A4. And the record of the mental capacity assessment was on one side, and the record of the best interest decision is on the other. We have now got that embedded onto System 1, which is the electronic record system that we use. And we've got it as a questionnaire with presets. Myself and our System 1 administrator worked with the care team on a one-to-one basis or 1-to-2 basis, so that they were confident in using the system, because, as I said, one of the barriers is a lack of confidence, and certainly a lot of our clinical staff don't feel their IT skills are up to it, but actually we've got it simplified really well now, which also then means that when we're looking at the care plans, so each care plan where we've got a young person who's unable to consent to that part or element of their care, they now have a mental capacity and best interest document that aligns to that care plan. Thank you, Heidi. And where the young person has been assessed as lacking the capacity to consent to their care and treatment, and that care and treatment constitutes a deprivation, then we'll apply for an urgent DOLS application. And we'll submit the relevant mental capacity assessment along with the DOLS application. It's really, it makes good sense now to the staff. And as I say, it's become part of the culture that, you know, we're automatically thinking, are we able to do this legally? They're far more confident now with the process. And our young people can come to us up to 4 times a year for a short break. And the same process is applied. So there's still the pre-admission meeting because things change. There's still the admission process when they arrive at the hospice. I then audit the clinical record. So I audit records on a Monday and a Friday, and I look at whether or not we've got the capacity assessments in place aligning to care plans, whether or not the capacity is unchanged or whether it has changed, whether or not their care needs have changed, and we need to look at reassessing capacity for a different intervention. The care plans will document then capacity assessed and remains unchanged, continue to treat in best interest, but we don't have to go back through the process of documentation because the documentation is there and still valid. And this is just to finish off with, really. And again, it's grounded back in that safeguarding the rights of others is the most noble and beautiful end of a human being.
Okay.
Thank you. And I don't know if we have any time for any questions.
Thank you, Jacqui. That was really, really useful. Yeah, thank you. Liz, do we have time? I can't see if there's any questions in the chat or comments or anything because I'm presenting, but
yeah, we have a couple of minutes, but nobody's asked a question as yet. But Caroline England, a guest, has said that she agrees with the video had difficulties with parents preventing those rights when we try to advocate for a young person. And other people have asked for the link for the video clip. It is in the slides.
It's in the slides, yeah.
Yeah, that will be sent out.
And yes, absolutely. Just going back to the parents, and you know, we feel for parents, and I think it's important that we give them the message that they still have the right in law for consultation. So it's not that a best interest decision is automatically going to be made by the professionals, because we have to prove that we have consulted with. And then there's the part as well, isn't there, in best interest about actually documenting if there's been any disagreements. Also, a caveat just to say as well that whilst we have really slimmed down our mental capacity assessment documentation, obviously, if this were to be a really serious decision that needed to be made, then it would take a lot longer, and the documentation would have to be it would have to go along with that as well. But the kind of decisions that we are assessing capacity for are pretty much the general interventions that are required for that young person during a stay.